Alrighty, y'all. This is Diesel with the People. This is Diesel with the People News. One more time at it again. Not attorney, not giving legal advice. This is educational purposes, right? Because what? People, take a guess. We don't look straight forward. We always look around us, be able to protect ourselves by any means necessary. All right. Once again, this is going to be coming from their YouTube channel, the Justice Revolution. Okay. If you want to see this whole video, it's entertaining, but this is the main point that I want to uh, show y'all. Okay. And it's a motion really just challenging the counties where they get their evidence that you owe taxes, basically. All right. Um, let's go ahead and proceed forward. Keep this short and sweet.
And clue and shouldn't be where they are because they think we're in a democracy. We're not. So if ever you hear somebody say the fate of our democracy is at stake, I would say good. This is not a democracy, nor should it be. And if the fate of our democracy is at stake, good. It needs to come down, and we need to get back to the constitutional republic that we are.
And the only way that we can do that is to hold them accountable to what they're supposed to be doing. If
Correct.
They're pretending to be our government, then we're going to let them know what their rules are. And if you can't do that, then they get away with whatever it is they're trying to do because you don't know your rights.
Yes.
And that's why I'm doing my darndest to learn it myself and to teach it to my children so that they can see what's coming.
Yeah. This is why, I'm so passionate about staying true to constitutionally sound principles. And I'll give you guys a quick example, and then we're going to wrap things up here so we can get the kids off to school, give them back their day. So you guys know that I recently filed a lawsuit against my county because they are trying to take property taxes from me, from my private property, and they're claiming they can do that because there's a constitutional principle that says property taxes are constitutional. So I filed a lawsuit. The attorneys on the other side, I'm not sure they can read or comprehend because they took my complaint and they filed a motion to dismiss based on two things. They filed a motion to dismiss saying that the court doesn't have subject matter jurisdiction. So hold that thought. They filed a motion to dismiss saying I failed to get relief. Basically what they're saying is that as a taxpayer, I didn't state a claim for relief. Do you remember what my entire basis of my complaint was, Erica?
That you're not a taxpayer.
That I'm not a taxpayer. My gosh.
Yeah, their whole argument is built on the assumption that you are a taxpayer, and that this is why all the rules you've broken are because you're a taxpayer. And you're saying, wait, I'm not a taxpayer, so.
Exactly. Because again, bar licensed attorneys swim in the sea of statutes. Okay? Statutes are what the men and women in every state's Congress and the federal Congress, that's what they write down on a piece of paper. They all vote on. They send it to the next chamber. They all vote on it. And then they send it to either the president or the governor to sign into law. That is a statute. Statutes are meant to govern the operations of the government. No statute can control our actions if it violates or contradicts any of our rights. Every state's constitution specifically specifies we all have a right to acquire, possess, and protect property. Okay, so Erica, if I have a right to own property, can the government tax that right?
I don't think so.
No, you're correct. They cannot. They cannot. There is Supreme Court decisions, multiple decisions, that say a right cannot be converted into a privilege and charged for a tax. Can't do it. Okay? So these attorneys in the case that I'm in now are trying to pull me back into the sea of statutes, and they want to make me think or argue based on those sets of laws, not on the highest law of the land, which is, what's the supreme law of the land? Isabel? Supreme law of the land, the Constitution. Yeah. Remember, sometimes some people listen to us on podcasts, so you have to talk.
Oh yeah.
So the United States Constitution and your state's constitutions are the supreme law of the land. Attorneys can't win there. And they know that, which is why they want to pull you down to the statutory side of things. Okay, so in my case, they filed a motion to dismiss. I filed a reply that said, hello, did you read my complaint? I'm not a taxpayer. I asked for evidence from you guys that I was. You provided no evidence, so therefore I am not a taxpayer. If you're stating I am, provide the evidence. Andrew, guess what they didn't supply? Just take a guess. Nothing. They don't have anything. They got nothing. So,
and I'm going to pause there for a second because he doesn't speak it. Which in turns, what? Silence, acquiescence, tacit agree to his terms. Okay? And never produced an affidavit to rebut his affidavit.
I recently filed a motion, and I'm going to put it up on the screen here, because when you look at the rules, what does Dr. Graves say, Erica, about the rules of the court?
You have to move the court.
Okay, but what does he specifically say about the rules?
I don't know specifically what the rules rule.
The rules rule. There you go. The rules rule. Okay. So when you look at the rules, and here's what I love about the rules. A lot of people in the patriot mythology world, well, the rules of civil procedure don't apply. They don't apply to us men and women, because per the rules of the common law, they don't apply. You need to read the rules, because when you look at the way that these are enumerated, these are our due process rights written out so it's clear as day for everyone to see. All right, so we have to make sure we call that out to the court's attention. So that's what I did. So these guys want to dismiss my case because they say that the court lacks subject matter jurisdiction. Well, guess what I found, Erica? What did I find, Erica? Right here under this.
Yeah, a federal rule of civil procedure that shows differently.
Exactly. So under Rule 12I, I have a right to ask for a hearing, and the court must grant me that hearing prior to dismissing this action. Additionally, I found court case precedent, which is also known as case law, that says if the court dismisses my action without granting me certain privileges, like what I'm about to talk about, then the court errs. It commits what's called abuse of discretion. So I filed this motion on Wednesday. So we'll say Friday. So Wednesday. And I said, I'm asking the court to grant me this hearing because the defendants are asking for a dismissal because the court lacks subject matter jurisdiction, or in the alternative, that I've failed to state a claim. And then I said this motion is based on the records, evidence, pleadings, and the supporting affidavit filed by the plaintiff with his pleading, because I submitted an affidavit, right? Isabel, how many times do you hear me talk about affidavits?
A lot.
All the time, right? Okay. So what do we do in our motions? We point out the points and authorities as to why the court should grant our motion. So the first point, the federal rules of civil procedure require a hearing. This is what 12I says. If a party so moves, any defense listed in Rule 12B 1 through 6, whether made in a pleading or by motion, and a motion under Rule 12C, must be heard and decided before trial, unless the court orders a deferral until trial. Okay? When you see the words heard, that is a hearing. The court must hold a hearing. So then I go on further and I say, where the defendants are moving this court to dismiss this action primarily on the defense of lack of subject matter jurisdiction, the plaintiff's due process rights require, at a minimum, that this court hold a hearing to determine the facts challenged by defendant's motion. And then I found this wonderful case law from the 10th Circuit Court of Appeals, which is the Court of Appeals that I'm in. And this is what it says. When a defendant moves to dismiss for lack of jurisdiction, either party should be allowed discovery on the factual issues raised by that motion. Although a district court has discretion in the manner by which it resolves an issue of subject matter jurisdiction under Rule 12b-1, a refusal to grant discovery constitutes an abuse of discretion if the denial results in prejudice to a litigant. So if the court grants their motion and dismisses my case, that constitutes an abuse of discretion because it would prejudice me because I can prove with factual evidence that I am not a taxpayer. They cannot prove that I am. Prejudice is present where pertinent facts bearing on the question of jurisdiction are controverted or where a more satisfactory showing of the facts is necessary.
So you've got them in a little pickle here. They're peeing their pants right now.
So the opposing attorney shot himself in the foot. And I'm going to reach out to them via email here shortly and see if they want to reconsider their motion again, because since they filed this under 12b-1, it requires discovery, and it's required that they prove that I'm a taxpayer.
You warned them, you called them, and you told them, I don't think it's a good idea for you to do this, and they did it anyway. Yep,
I did. So here's the other interesting thing. When a defendant attacks a pleading, and they're saying that the court lacks subject matter jurisdiction, there's the way the courts look at that is one of two ways. Either it's a facial attack or a factual attack, and I'll explain what that means. And I said the defendants, by and through their counsel, have asserted that the court lacks subject matter jurisdiction to hear this case. It is unclear whether this attack is a facial attack or a factual attack, as within their motion to dismiss, they claim plaintiffs stated no factual allegations, yet failed to support those claims with any evidence to support those assertions. Similarly, they state numerous times that the plaintiff failed to assert any factual allegations, which would suggest that this is not a facial attack. So again, I find more case law here in the 10th Circuit Court of Appeals. A party filing a 12b-1 motion to challenge the court's subject matter jurisdiction through a facial or factual attack. This is what a facial attack means. A facial attack assumes the allegations in the complaint are true and argues they failed to establish jurisdiction.
A stall tactic.
Correct. A factual attack goes beyond the allegations in the complaint and adduces evidence to contest jurisdiction. So it's one or the other. Either they assume my allegations are true and the court still lacks jurisdiction, which I've already proven that can't happen. Because if they assume the allegations in my complaint are true, this court has jurisdiction to hear my case.
Right.
So it's not a facial attack. All right, so we set that one aside. A factual attack goes beyond the allegations and adduces evidence. Okay, so now they're saying that the allegations are not true, and they would bring in evidence to support that. They have brought no evidence to support that.
All right. And again, I'm not an attorney. I'm not giving legal advice, okay? This is educational purposes only, in my opinion, right? Now, we're going to go back into the what? The four corners, okay? It must stick into the general standing of the documents, right? They're kind of weeding out of the four corners. Like they caught their hands in a cookie jar, so they're kind of doing playing with the judge's mental state in a lot of ways, even though the judge knows what's going on. But if you guys have been through this before, go back and read your own paperwork that your attorney did with your taxes and see if this is actually in line of what he's doing, right? Because 9 times out of 10, the other party either don't do the research or they're just playing footsies with one another. which is not beneficial to you. However, if you go in there and say you're a taxpayer, you're in the wrong standing of the courts, and the judge must rule that you're a taxpayer since you admit to it.
So I said, seeing that the defendants failed to submit to this court any evidence in support of their factual claims and deny in a roundabout way plaintiff's factual claims, this court is required to hold a hearing to allow both parties the opportunity to present admissible evidence in support of their positions, which thus may require discovery. Uh-oh. So here's what I'm asking. This court should order a Rule 26F conference and the defendants be required to answer the pleadings. So 26F is the rules of discovery. And the parties are required to confer to submit their discovery plan, what they're going to ask for, what they want. I've already got most of everything I need. I can prove my case with just my complaint. But both parties...
They're going to have to bring on like 5 more lawyers just to deal with it.
Yes. But... they're going to have to submit those positions. So, given that the rules of civil procedure, as well as multiple decisions from the 10th Circuit Court of Appeals, require discovery and a hearing, this honorable court should order that the parties convene for their 26F conference for discovery, and that within 14 days after this conference, the defendants be required to answer the plaintiff's complaint, as their answer will go to the heart of the factual contentions contained within their motion. Then I state here, the district court must permit a full development of all the facts before making a determination of jurisdiction.
Good.
Okay? So that's how we bring these people back. That's how we get them back into where they need to be, where we want to be. So here's my next move. I'm going to send an email to the attorneys today, and I'm just going to say, hey, gentlemen, given that it looks like you're making a factual challenge to the court's jurisdiction here, I would ask that we hold some type of a conference or something of that nature to determine what evidence you plan to present in support of your positions. So,
I love it.
And that way we can get back to the court on this. So, any questions about that?
It just goes to show how important it is to learn the rules of the game better. I mean, it's like your brothers asking you to play Monopoly with them, and then you don't know the rules to Monopoly, so they dominate you and they like crush you, and they end up with all your property because you don't know anything. But if you study the rules and you study the strategy and then you go back to the game table, then it's like a different game.
It's hard to play Monopoly with my brothers.
Yeah, none of us like to do it. They go, they're power hungry.
I love it, but they just take too long.
Isabel, what do I say about basketball referees who don't know the rules?
They really need to read the rule book because there's some refs that don't know what they are doing, and it's so annoying.
Yeah, because haven't when I was coaching you, what did I? How did I teach you to play the game? You remember?
Give it my all.
Yeah, well, yeah, but what did I specifically told you and your teammates what the rules were and how referees look at certain plays, right? So I taught you to play the game according to the rules as I know them, being a 15-year veteran referee. So I know the rules. And so it frustrates me beyond anything else that when we send our kids out to play a game and those that are there to enforce the rules of the game don't know those rules. Would it shock any of you that this happens in our courts of justice as well? No.
I bet those lawyers are going to have to go look up a lot of those references because they don't know them.
Absolutely.
In any trade, like there are
Absolutely.
medicines that I would come across as a nurse that I'd never even heard of before. So before
Absolutely.
I give it, you need to know what the side effects are. It's not.
Mm-hmm.
Yeah, it's important to know.
If we can boil down these things, the way to win your case in any court matter is the party that has admissible evidence that proves their point will win. You may not win at the trial court, You might have to go through, like, especially if you're in one of these stupid municipal courts, you might have to go through 2 or 3 of these song and dance or these pony shows before you get to an adult in the room at the appellate court level where they're like, what are you idiots doing? This guy's got the evidence right here. It specifically says this. The law says this. Judgment in favor of this guy. Okay? We have to make sure we do that. So,
and I'm going to leave it right there. This has been 20 minutes, right? What do? You use their rules, their statutes against them, people. Just saying. Diesel with People News. Till next time. Bye, y'all.